You know, every once in a while, sitting out on my own little island in the shanty catches me out. So Sunday afternoon, I did a shanty. I recorded a shanty on Governor Whitmer's overturning the right to work law and reinstating the prevailing wage law, and I included some other stuff in there. What I didn't know was that my fabulously talented colleagues in the Labor and Employment Practice Group were already in the process of writing a brilliant eAlert on the very same topic, which came out Monday morning. So while I was sitting out by myself on Sunday and then on the road on Monday, not paying attention to what was going on, that eAlert was issued. Now, normally we don't like to duplicate our efforts between eAlerts and the shanty broadcast, but since I already did this and since it's already recorded, we're going to publish it anyway. So if you don't want to watch it, you already read the eAlert, don't bother. If you do, that's great. See you next time. Hey everybody, welcome back to the shanty. It's a dreary Sunday morning in the shanty, and I'm angry at the governor. Why am I angry at the governor, you might ask? Think back, if you will, to when we were going through COVID, such a pleasant time for everybody. It seemed like every time the governor wanted to do something new, she would announce it at 4 o'clock on a Friday. And then my colleagues and I would get to spend an entire weekend trying to figure out exactly what it was the governor said, what she wanted to do, and what it meant for you, so that we could tell you what it meant for you. This is kind of the genesis of this thing, right? So I guess we have the governor to thank for that. Thanks, Governor. Well, she did it again. Friday at 3 o'clock, the governor signed into law 3 new bills that are now, or will, on their effective date, become laws in the state of Michigan. The big one that we'll talk about a little bit here is the repeal of the so-called right to work law in Michigan. But it's been a busy couple of weeks in the legislature in Michigan, and it's been a busy couple of weeks here at good old Warner, Norcross, and Judd. So I'm sorry I'm just getting around to this, but I am. So before we talk about those 3 bills, I want to go back a couple of weeks to March 16th, because on March 16th, the governor signed into law a new bill, a Senate bill, that amended the Elliott-Larsen Civil Rights Act. That is Act number 6 of Public Acts of 2023, formerly known as Enrolled Senate Bill number 4. And it's entitled An Act to Define Civil Rights to Prohibit Discriminatory Practices, Policies, and Customs in the Exercise of Those Rights, blah, blah, blah. So what does the amendment to Elliott-Larsen do exactly? Well, for your purposes, here's what it does. It adds to the list of protected categories under the Elliott-Larsen Civil Rights Act sexual orientation, gender identity, and gender expression. So I'll read to you exactly what the act does. Section 202 of the act states, quote, an employer shall not do any of the following: fail or refuse to hire or recruit, discharge, or otherwise discriminate against an individual with respect to employment, compensation, or a term, condition, or privilege of employment because of, and here comes the list, religion, race, color, national origin, age, sex, sexual orientation, gender identity or expression, height, weight, or marital status, period, end quote. Now, for a lot of you, this is not going to be anything new. It's not going to require you to make any changes because you're covered by Title VII. And you were already doing this because the Supreme Court, was it last year or 2 years ago, whenever it was, time flies, held that sexual orientation and gender identity were encompassed for Title VII purposes within the term sex. Now, this is a little different. This bill doesn't encompass sexual orientation and gender identity or expression into the term sex discrimination. It adds those terms to the list of protected categories. So when the Title VII ruling came down from the Supreme Court, you might not have changed your policy because you already had sex in there. And technically, if those things are encompassed within sex, as long as you had sex in there, you were good to go. But now we have a state statute that actually mentions those three things: sexual orientation, gender identity, or expression. So what should you do? Well, you better go look at your policy and make sure that your policy has those terms in it. Now, if you've already made those changes because of Title VII, that's great. If you're not covered by Title VII or you didn't make those changes, now might be the time to do it. You want to look at your EEO policy. It might be in a bunch of different places. It's clearly going to be in your handbook. But wherever you have that list of things, let's add sexual orientation, gender identity, or expression. Okay? So that's issue number one, and that's the first thing the governor did a couple of weeks ago. On Friday, we had three other new employment-related bills or labor-related bills that the governor signed into law. Now, why is this happening? Well, look, we have a new Congress now in Michigan, right? We have a legislature that is, the House is controlled by the Democrats, the Senate is controlled by the Democrats, and the governor is a Democrat. When that happened, they came out and told us, we're going to make some changes, and they've started to do that. Okay? So the governor signed into law three new bills. Enrolled House Bill number 404 is the first of those three bills. It becomes Act number 9 of Public Acts of 2023, so it's got to do with the order in which she signed them, whether it's 8, 9, or 10. And that bill deals with public employees only and labor relations for public employees and what public employees can do and what they can't do. And it amends a really old public act that goes way back to 1947. And unless you're a public employer, this doesn't have anything to do with you. So I'm not going to spend a lot of time going through it. All right. The next bill that the governor signed was Enrolled House Bill number 4007, which is now Act number 10 of the Public Acts of 2023. Now, this bill has to do with construction contracts for the state, and it restores what's called prevailing wages. Now, what that means, for those of you that don't know, is when you work on a construction contract for the state of Michigan, you are now required, and I say now required, you are now again required to pay a prevailing wage, which is set based on lots of factors that we're not going to get into, but almost always it's higher than whatever you're paying your employees. And along with that, you have to pay a specific menu or amount for fringe benefits. And this is for those of you that work on state construction contracts. Now, this law went away when the Republicans controlled the legislature and when, I think it was Governor Snyder, was in office. It went away. Now, we still had it for federal contracts. It's called the Davis-Bacon Act. So those of you that do Davis-Bacon work, you already know about this. You've known about it for a while. And those of you that have been in business since before 2010, none of this is new for you because 2012, not 2010, which is when I think it was overturned. You were doing this kind of work already anyway. You were doing this thing for your employees already anyway, so it's back now. All right, that's change number 2. Then we get to the big one. All right, and that is Enrolled Senate Bill number 34, which is now Act number 8 of the Public Acts of 2023. It's the one that you're reading about in all the news flashes and all the other law firms that have done eAlerts that you get and all that stuff. This is the law will be law when it goes into effect, that overturns what we call right to work, okay? Now, right to work laws are, as you know, laws that make it illegal to require people to pay union dues or service fees to unions. So if you go to work for a union company and they want you to join the union and pay dues or service fees, if you live in a right to work state, you didn't have to do that if you didn't want to. Well, this overturns that right. Now, it's interesting to me the way the governor framed it. In a press conference, she said things like restoring employee choice. I don't know how making an employee pay union dues or service fees is restoring employee choice, but that's what this is being sold as, protecting the middle class, restoring employee choice. Whether you believe that or whether you don't believe that, that's entirely up to you. But here's what it does. This statute now puts back into place the law in the state of Michigan as it existed prior to 2012. That is, you can have so-called union security clauses in union contracts. What is a union security clause? Generally speaking, a union security clause is a clause that says when you come to work here after a specific period of time, it's usually a 90-day probationary period, you must either join the union and pay union dues or pay a service fee to the union, and it comes out of your paycheck once a month or twice a month, but it comes out of your paycheck, and that money goes to the union. So this bill, in its important part, says the following. An employer and a labor organization may enter into a collective bargaining agreement that requires all employees in the bargaining unit to share fairly in the financial support of the labor organization. This act does not, and a law or policy of a local government must not, prohibit or limit an agreement that requires all bargaining unit employees as a condition of continued employment to pay to the labor organization membership dues or service fees, period, end quote. Okay, so we're going back to where we were before 2012. We are no longer a right-to-work state. And by the way, to the best of my knowledge, Michigan is the first state that has repealed its right-to-work law since in the modern era, let's call it. And I think there's 26 states left now without Michigan that still have some sort of right-to-work law. All right, so what can we do about it? Well, we'll just go to the ballot and we'll do a referendum and we'll overturn this thing, right? Because clearly this can't be what the people of the state of Michigan want. Not so fast. In addition to that paragraph that I just read you, another provision of this act actually appropriates $1 million to the Department of Labor and Economic Opportunity to do all of the following according to the act. Respond to public inquiries, provide a commission with sufficient staff, blah, blah, blah. There's 4 things it lists, but it appropriates $1 million. Well, why? First of all, why do you care that it appropriates $1 million other than it's your tax dollars? And why am I telling you that? I'm telling you that because under Michigan law, when there is an appropriation like that attached to a bill, that bill is not subject to being overturned by referendum. So the only way this thing gets overturned is we get a new Congress that says, nope, we're going back to right to work. Or we get a constitutional amendment that overturns this statute. Or a court, a Michigan court, not a federal court, says that's unconstitutional, you can't do it. Probably not going to happen with our Supreme Court. So what does this mean? What do you do? Well, if you don't have a union, you don't worry about it until you have a union campaign. And then we're probably going to use it as opposed to not. If you do have a union, there's probably one of 3 things that you're going to have to do. Some union contracts, and I know the UAW was doing this for a long time, kept their union security clauses in their contracts all during the right to work law. And what they did is they just lined them out. And then they added a paragraph that they negotiated with the employer that says, if right to work is ever repealed, this union security clause that requires the payment of dues or service fees goes back into effect. Okay? The other thing that you might have in your union contract is a reopener. In other words, a paragraph that says, if right to work is ever repealed, we will reopen the contract and negotiate a new union security clause. You can bet your bottom dollar, if those things are true, that the union's going to be knocking on your door pretty soon saying, we want our union security clause back in the contract. Well, what if you don't have a union security clause, but you're an employer, a union employer? Well, the next time you negotiate your contract, the first thing the union's going to ask for is a union security clause. Why? That's how they make their money, right? Through dues. That's how they make their money, through dues and service fees. So they're going to want these in the contracts and back in the contracts. So those are the things you need to look for when you do this. So when does this go into effect? Well, that's a really good question. So the bills were passed, what they call, all but one of these bills, and the one that doesn't have anything to do with us, the public employer bill, were passed what they call, they have an effective date listed on them called Cindy. It's not Cindy like Cindy, the woman's name. It's Sin, S-I-N-E-D, Sindai, I guess it is. It's Latin. What do I know? I'm only Italian. I should be able to speak Latin, shouldn't I? Sindai. Well, what does that mean? It roughly means no date. So when a bill is passed that way, what happens is, and you should all be familiar with this from when we talked about the Paid Medical Leave Act and the Earned Sick Time Act and all that, blah, blah, blah. It goes into effect 90 days after the end of the legislative session in which it's passed. Well, when does the legislative session end? Normally, this legislative session would end sometime in December, and then these bills would go into effect and become law in March-ish of 2024. However, the legislature does have a right to declare a session closed in, say, July, and then the bills would become effective, the laws would become effective 90 days after the legislature closes the session for the year. And the legislature can do that even if they're called back into a special session. That's okay. So it's either going to be March of next year or it's going to be 90 days after the legislature declares a close of this current session, which could be as early as, say, September. If you have any questions about any of this, give your Warner Norcross and Judd labor lawyer a call, and we'll be happy to walk you through it. Hope you have a great day. Talk to you later.